record to this computer.
Great.
Okay.
Okay, hello everyone. My name is Haley Dorenzo. I am an attorney and one of the directors of eviction defense with CED Law, which is the law firm branch of the Community Economic Defense Project. And we do a lot of work supporting tenants and homeowners throughout the state of Colorado. We work all across the state, and we're so excited to talk with you today. I understand that many folks are teachers, educators. Your work is so important, so I'm really glad to be able to partner with you all and to present to you today. We do have a small group, so if you do have questions or there's sort of particular topics you would like to cover, hello to new folks joining. If there is sort of a particular topic that you're wondering about, topic that you'd like to hear more about, please put that in the chat or go ahead and raise your hand or just speak out. Let me know whatever you feel comfortable with. I do have a presentation, but definitely want to make sure this is useful for folks. So if there's sort of specific things you're wondering about, please feel free to shout those out with the caveat that I do want to keep things hypothetical tonight. So if you are, looking for legal advice as to a specific situation that you are dealing with, what I'm going to do is direct you to our online intake form, where we can get some more information from you and see if we might be able to assist you with actually, providing you direct legal advice. Not going to provide any sort of specific legal advice on this presentation tonight, but definitely can talk generally about, some issues that may be very common, such as, issues with heat. We obviously just got through this very cold winter. So I hope that we were all able to be safe inside warm homes. Some of our neighbors are not so lucky, and so that is something that comes up a lot that certainly we could talk about if people are uh, more interested in hearing more about that. Okay, so unless there's any sort of specifics, and again, feel free to throw questions or topics into the chat throughout the presentation, but I'm going to go ahead and get started. So I'm going to share my screen and pull up our presentation here. Can someone give me a thumbs up or just let me know that you can see the presentation?
Absolutely.
Yes, okay, perfect. All right, so we are going to talk tonight about particularly living conditions. And so this is going to be focused on tenants, renters, and the rights that you all have in your homes, and the right that you have to live in what is called a habitable or a livable home. So that is what we are going to be focusing on tonight. Okay, so to start off, you have the right to live in a livable home, or what is sometimes called a habitable home. Colorado has recognized this right for a long time, and actually last year in May of 2024, the legislator in Colorado extended these rights, added some different protections, different things to help tenants that we're going to be talking a little bit more about tonight. So quick overview, kind of high level picture here, a couple of big things that violate or breach Colorado's warranty of habitability, which is what that right is called. Every lease has what's called a warranty of habitability, which means the right to a livable home. So two big things that breach that, kind of two different categories, are when a property materially interferes with a tenant's life, health, or safety, or is otherwise in a condition that makes the home uninhabitable under the statute. And we'll talk about what, examples of what those look like. And then it breaches the warranty of habitability when a landlord receives notice of one of these conditions and does not fix the condition within a specified time frame. And we're going to talk about those time frames. And so it can either be that the landlord rents a property that is uninhabitable from the get-go, that they rent somebody a property that does not have adequate heat, or something like that. Or maybe those things were working initially, and then a tenant moved in and something broke, something happened, and then the landlord did not fix it after receiving notice. So those are kind of the two big categories. A lot of text on this slide and throughout this presentation. Don't feel like you need to, read or jot down notes on all of this. Happy to provide a copy of this, but going to talk through some of these big examples. We have a lot of text on some of these presentations because we sometimes do them with translators, and that can be helpful for them. But these are the two categories of what might make a home uninhabitable. So there's a subset of categories of things that materially interfere with life, health, and safety. And these are kind of like the top tier, like very dangerous situations, and they are going to be dealt with on a more expedited timeline. So some things you might see here that maybe you've experienced, or somebody who's experienced, or maybe you've just been worried about some of these things because they're serious things. These would be things like issues with the gas facilities, not having running or adequate water or hot water, lack of heat, like I talked about earlier, issues with electrical systems, electrical facilities, not having working locks. So that can be a safety issue, right? To not be able to lock your home. Plumbing issues, and then infestations of certain types of animals that might cause disease, things like that. A couple other things in here as well, but those are kind of the big heavy hitters, so to speak. And then things that might otherwise make a home uninhabitable could be mold. There might, be times that mold might cross into this materially interfere with life, health, and safety category, but typically mold falls into this other category. These could be things like issues with a common area. Sometimes we'll see common areas are very dirty, or maybe things are broken, things like that. Not having adequate amounts of garbage facilities, receptacles, so that, maybe garbage is piling up, things are overflowing, stuff like that. Certain appliances not working. So stove, oven, refrigerator, we see a lot of those, or maybe that they are just missing from the home. That would fall in this other category here. Maybe issues with the floors, issues with the stairs, just things kind of falling into disarray, not being in good repair. And then a sort of new thing here that is relevant, and people have a lot of interest in, particularly as Colorado is getting warmer. I don't know if any of you are from Colorado, but I'm from here. I grew up here. And I feel like there used to be this kind of idea that like you don't really need air conditioning in Colorado. Maybe that was true, 10, 20, 30 years ago, but it certainly is very uncomfortable, can get very, very warm here in the summers now. So a new part of the warranty of habitability is that a landlord's not required to provide a cooling device, but if one exists in the home when they rent it to you, then they do have to keep that cooling device in good repair. So if it's an air conditioning unit, they would need to fix it, things like that. Again, this is a newer part of the law, so I think there are open questions as to if it's central air and it breaks, but they install a swamp cooler, is that sufficient? I think we'll sort of see more how that all plays out. as people start using this law more, but I thought that was exciting and you know, I think important as we move into more of these hot summers. So a couple more things there that we didn't touch on, but those are kind of the main ones for both of these categories. All right. So in order for the landlord to actually violate this right, violate this warranty, it's not just that the condition exists, but the landlord has to have notice. This side over here, rather than tenant must give written notice, it really should say the landlord must have written notice. And the reason for that is that the tenant can give written notice, and that is typically the best way to let the landlord know and to make sure you've met this requirement. And you can do that by sending an email, sending a text. A lot of folks who live in maybe big apartment complexes might have like a maintenance portal that would qualify as a written notice. You can handwrite a letter and send it off. Definitely recommend if you do that, that you like take a photo of it, or if you mail it, have a tracking number or something like that. So you could later prove that you did provide that notice. But that's going to be kind of the best way to make sure landlord's aware of this is you yourself, the tenant, to provide that notice of the issue. Want to be as detailed as possible. Also want to be cooperative with the landlord if they are going to try to fix it, right? So if you let them know, I have this issue, my heat is broken, it's very, very urgent, like it needs to be fixed, but then they're trying to sort of come in and fix it, and you're saying, no, you can't come on this day, and kind of have all these requirements for when they can come in, that can make it more difficult because they're going to say, well, we tried, but the tenant wouldn't let us in. And sometimes we do see situations like that. But important thing here is that other people can actually now provide the landlord written notice. So it used to be that the tenant had to provide written notice. So we would get a lot of folks who maybe talk to their landlord about these things on the phone. Some leases will even say, call this maintenance number, right? And like that's the way that you report the issue. But now if the landlord has any written notice of the issue, then that's going to meet the qualifications of the statute. So that could look like possibly code enforcement or like the health department coming in and taking documentation, writing down notes, making some sort of record of what's going on in the property and giving it to the landlord. It could be a different tenant. Maybe a different tenant has complained in writing that there is like a big mice infestation in the apartment complex, and therefore not every single tenant has to provide notice of that in writing. Could be a group of tenants, like a union or something like that, community organizers, maybe nonprofits working with tenants, on their behalf. I also think that, say a tenant goes and says just in person, hey, I'm having this issue at my property. Say it's like a bug infestation or something. And then the landlord maybe finds somebody online and is sending emails to them and saying, hey, can you come fumigate? I would argue that that could also be written notice. So this is an area where the law really expanded this, made it a little bit easier for tenants to prove this notice, because otherwise in the past, if they couldn't show that they had provided the notice themselves, then they couldn't sort of get remedies under the law in this area or move forward with this defense if they were in an eviction posture. Another important thing about notice is to make sure that if you are dealing with something like this, even if your landlord's super friendly, you have a really good relationship with them, you definitely want to make sure to just document the conditions. So take photos, take videos. It can even be a good idea to sort of journal or keep a timeline of what was going on, particularly if your landlord maybe is doing some things to resolve the issue. It can be good to sort of keep track of the dates and such, because sometimes you'll get into a situation where the landlord's kind of doing the bare minimum, and from their perspective, they're trying, but you might get to a place where the actions they are taking are not reasonable because the issue's been going on for so long. So we see that sometimes with like infestations, that yes, the first step with mice is often printing out a few traps, hoping maybe it's just a couple. But if that doesn't resolve the issue, then you might need to, hire actual exterminator or, do something more intense than just putting out a few traps. Sorry to be talking a lot about bugs and mice. Those are good examples for these types of things. I know that they are gross, and I hope no one has really ever had to deal with them. I have, and it's not fun. Okay. So once the landlord has notice, I guess backing up a little bit, these are just requirements of the landlord. So the landlord is required to ensure that the property is in a habitable condition when they lease it. So that kind of goes back to that first category we talked about of the landlord, if they know that the heat is not working at the property, that there's an infestation, that there's no hot water, whatever. They shouldn't actually be leasing the property at all. They should be fixing those issues before they lease it. But if you're then in the home, you provide notice of some sort of issue, the landlord is supposed to begin remediating the issue within 24 hours if it's an issue that materially interferes with life, health, or safety. So again, going back, that's going to be these on the left side. And then they have to begin remediation within 72 hours, so a longer time period, if the issue falls over on this right side. And then they are supposed to actually complete the repair within a reasonable time, which is going to be 7 days for those life, health, or safety issues, and then 14 days for those other issues. And that means that the issue is like completely remediated. So it used to just be that the landlord had to, take efforts within these hour timeframes. But then, what does that mean? Begin efforts could be they call somebody, but nobody comes out to the property, right? So there's a little bit more clarity here now. One thing that a lot of folks aren't aware of and that can be really important for these types of situations is that in certain situations, the landlord is required to provide an alternative unit or hotel room. If it's a hotel room, it does need to have, or either the unit needs to have a stove and a refrigerator, or if it's a hotel room and it doesn't have those types of things, then the landlord would also need to provide a per diem for like meals and incidentals. And that's based on this Colorado per diem rate, which I think is around, I think maybe like $40 a day, something around there. It's not anything extravagant. But typically they'll try to kind of do which one would be the cheaper Airbnb with the fridge and all these things, or hotel room, with the per diem rate. And that would be for situations where the home, it's very unsafe. Maybe there was a flood, something like that. They are actually supposed to move you into a different type of unit. You have to request it, but that is something that you have a right to under the law if the warranty of habitability has been violated. In this situation, you still pay your rent. So you pay your rent to the landlord, but since you can't live at the home, they're putting you in this other place, but they don't put you in this other place, and then you don't have to pay the rent, right? So you still do have to do the rent obligation there. And this can be for up to 60 days, maybe while they're making repairs, things like that. Okay, the landlord should also maintain accurate and complete records. So if you provide notice, they're supposed to maintain that. They're not supposed to just like get rid of it, so that if you needed it later in like a court case or something, they should have a copy of it. And also that would be, stuff related to maintenance, hiring, repairing the issue. And then down here, we talk about breaking a lease after some sort of catastrophe. So, there was just obviously ongoing in LA, all these fires there. There have been, bad fires in Colorado before as well. That would be something like a catastrophe, that maybe a house burned down, and you just can't live there anymore, right? Because it doesn't exist. So there is a provision about not being able to break leases because of a catastrophe if there was a warranty of habitability issue prior to that. So in reality, what that might mean is maybe the landlord having to put, again, the folks up in like a hotel or something for that time period while they're maybe finding another place to live rather than just immediately terminating the lease because of a catastrophe, a fire, a flood, something like that. Okay. And then these are tenants' remedies. So what a tenant can do when the landlord breaches the warranty of habitability. Some of these things are, you don't have to go to court for. And then some of them you could try to negotiate with your landlord to try to get them to offer you, and they might not. And then you could try pursuing things in court, either as what's called an affirmative claim against the landlord, which means you sue your landlord. Or if you are defending against an eviction case, which oftentimes happens at the same time as some of these things going wrong, you can raise that as a defense in an eviction case. So one of the most common things that we will see, or perhaps sort of the easiest in some ways remedy, is that a tenant is allowed to break a lease without penalty if the warranty of habitability has been violated. And so without penalty, usually in your lease, you probably have a provision that says if you break the lease early, you owe this fee. And a lot of times it's the equivalent of like 1 or 2 months rent. And that is because, the landlord entered this contract with you. They're thinking they can rely on you to pay the rent every month for the period of time that you leased. And if all of a sudden you leave, that's kind of like their damages. So they get to collect that fee from you for essentially like breaking the contract. But if there has been a warranty of habitability issue, it has not been resolved within the time frame, and you provide your landlord between 10 and 60 days notice that you are going to leave, then you can break the lease without fee. If they don't fix that issue within the time frame. So if you tell them, hey, I'm going to move out in 30 days, unless this is fixed, they have that time to fix it. But if they don't, you can move out and there is no fee. There's also a situation where you don't have to provide this notice. You don't have to give them that time to fix it if the same condition has been violated more than once in 6 months. So this could be like the heat breaks, they fix it, but then it breaks again like 3 months later. And that might be a situation where you say, I just want to move out. So this can be an option, and you definitely want to, this is a good example of wanting to document everything in writing, making sure that you have documentation of the habitability issue of you fitting within this time frame, in case the landlord does try to, tack on or take out of your security deposit that lease break fee, that you would have sort of this paper trail of why you don't owe that fee under the statute. This is, sometimes works for people. Sometimes this is what they want. I would say most people, probably don't want to move if they don't have to, right? They prefer that the issue just get fixed and they can stay in their home. So some other options that tenants have, one is being able to deduct the cost of a repair from the rent. This process is a little bit complicated. It has many steps. So you have to first give your landlord 10 days notice that you are planning to deduct a cost of some repair from your rent. And you have to get like a quote, a good faith quote from a professional, and provide it to your landlord. The professional cannot be someone who's related to you, even if they are, even if your dad is a plumber or something like that. It can't be someone who's related to you, just for probably bias purposes or things like that, making sure it's an objective quote. And so you provide that to the landlord, and then the landlord can, fix it themselves or sort of hire their own person. But if they don't, then you can let the landlord know, with a receipt, hey, this is how much this cost me. And then you can deduct it from the rent if you've given them those 10 days notice. Again, some people might be in a position to do this, to hire somebody to fix something themselves. But a lot of people aren't, right? Sometimes these fixes can be expensive. And also certain things, if you're not the homeowner, the person, might be like, I'm not gonna touch your heater, or I'm not gonna do this unless I have the homeowner's permission. So I honestly don't see tenants doing that a lot, because it can get a little complicated, but technically you do have the right to do that. You also always, even if you don't give your landlord that notice, you always want to keep track of anything that you're paying with your own money because of a warranty of habitability issue. And again, this could be that if you maybe get behind on rent and you're facing an eviction case, that could be a defense that you had this warranty of habitability issue. And you can show the court, I had to buy these big industrial fans because my basement flooded. My landlord didn't do anything about it. I had to get rid of this expensive workout equipment and I had to buy a new TV or whatever it is, right? Always want to make sure to have receipts and sort of keep a list of that type of stuff in case you do find yourself in that situation.
Okay.
Go
I'm
ahead.
getting a I'm getting a conversation in the chat.
Yeah.
Are you seeing, and this seems like a good general question, um, are you seeing landlords using the damage deposit as sort of a competitive weapon on this stuff? Well, you can move out, but we're going to assess damages back. Or is that part of the statute as well?
Yes, I would say it's very common that even when a tenant did these things correctly or was able to move out, under the statute without a penalty or something like that, that what will end up happening is the landlord will deduct whatever they can from the security deposit. And security deposits is a whole different presentation. Would be happy to do that another time as well, because I think that's definitely an area of interest for a lot of folks. Because a lot of us have probably had the experience of having our security deposit like unjustly taken from us. Um, and the process to challenge a security deposit like withholding is actually, nothing in the law is simple, but it's one of the processes that I would say is like fairly pro se, which just means doing it without an attorney friendly. And what you have to do is you have to provide your landlord like a demand letter and say you withheld this like, incorrectly, and then demand that they refund it to you within 7 days. And then if they don't, you can file something against them in court. And it's in county court, and unless the damages are like really higher than $25,000, but they typically would not be. And of course, filing something in court on your own feels really scary. But definitely have seen tenants do this on their own without an attorney, with some success. So it is possible. But yes, that is something that we would see and that you potentially should be prepared for, but just know that there is a process you can go through to fight to get your security deposit back if your landlord has, withheld it. And if the deposit doesn't cover everything that they're saying, maybe they're saying you caused all this damage to the home and you owe me a $3,000 lease break fee, then a lot of times what they'll do is like send that to collections unless you pay it on time, which again it's a whole other thing of sort of how to navigate debt collection. But there are ways that you can dispute debts like that as well. So yeah, that's definitely another topic. I'd be happy
Awesome.
to talk more about that another time. But short answer is yes. That was a little bit of a tangent.
Short answer is yes, and long answer is there are still ways to fight that.
Yes, absolutely.
Come to our East Colfax clinic for more details.
Um, okay. And then You can also deduct for the cost of replacing an appliance. The notice period here is a little bit less, only have to provide 3 days notice to the landlord, and then have to you can replace the appliance with something of comparable quality. So, that would mean that if you had kind of maybe a fridge that didn't have all of the gadgets or whatever, and then you replaced it with this really fancy fridge that was a lot more expensive, might not be able to deduct that full cost. But also might get in a situation where maybe your dishwasher was like very, very old and there was just no model that was really comparable to the one that you had. And so you had to get kind of a newer, more expensive model. But again, we see that a lot, that comes up a lot with appliances breaking. And then another remedy that a tenant has is actually being able to collect damages for living in a home that was unlivable, that violated this right. That would be a situation where you would need to either raise as a defense in an eviction case the violation of the right, or bring your own lawsuit about this issue, which these cases are definitely a little bit more complicated. Not to say that you couldn't do them on your own, but definitely helpful to have an attorney. The folks who do housing cases in Colorado take some of these cases, but it's a much smaller amount. All of us take a lot smaller amount of these cases because we do so much eviction defense, and these cases just take longer, take more resources, take more time. So I don't want to be sort of naive about the fact that it can be hard to find an attorney for these types of cases. And then same thing, if you're in court, you can also ask the court to order that the landlord repair the conditions. Going back to most of the time, what a tenant wants is just for the condition to get fixed. They want to stay there. They want to continue, paying their rent on time. They don't want to have any problems with their landlord. But if they're having all these problems with conditions in their home, then, they need something to change. So that can be another option as well. And then we've talked a little bit about that you can raise the breach of warranty of habitability as a defense in an eviction case. And you can get these remedies when you raise it as a defense as well. You don't have to bring it as a separate claim in order to get some of these remedies that we've talked about. And the court can also, like if it's a non-payment case, the court can order that whatever you owe in non-payment is actually $5,000 less or whatever it is, taking into account that you've been living in this home with all these issues for so long. So those are different things tenants can do. This is not on the presentation, but I also a lot of times recommend and have seen people find success with, particularly with things like heat, some of that stuff that falls into that life, health, and safety category, with getting the health department involved. And you can contact them through 211 if you're outside Denver. Denver is 311. I think everyone here is outside Denver though. And basically, make a complaint, and they will send an inspector out to the property, and then they will issue like a letter to the landlord that says, you need to do these things, and if you don't do them within this time frame, we will fine you. This is different than warranty of habitability. Technically, what they're doing is enforcing city code or county code about, health and safety, but there's a lot of overlap. So if they go to your home and they see that like the ceiling's caving in, or the stairwell is in disarray, or there's no heat, there's no running water, there's electrical issues, things like that, those are all things that are going to be code violations that they're going to issue that letter to your landlord saying, hey, you need to fix these things. Code enforcement or the health department, if you do find yourself in a court case eventually, whether it's an eviction case or an affirmative case, those folks can often be very helpful witnesses, where they can testify to what they saw in the home, their expertise of being a code enforcement officer, why these things are unsafe, and they're an objective witness, right? They don't really have skin in the game. They're not really trying to help the landlord, or like they're helping the tenant in a way, but they're not like, they're still objective, right? So they can be a really good witness for these types of things. And definitely with some of these severe things, I found that especially after maybe you've reached out to the landlord, nothing has happened, you're trying to sort of do all these different things and you just haven't really been able to get anywhere, that getting code enforcement involved can be very helpful. So like to flag that for folks. But that does bring us to our last section, which is about retaliation. So Colorado law does prohibit the landlord from retaliating against a tenant for raising these types of complaints, for getting code enforcement involved. Not what we're here to talk about today, but also for organizing, trying to create a tenant association or a tenant union or otherwise organizing. And sometimes folks are doing that perhaps because of conditions issues throughout the property, right? And so there is a statute that says that it is illegal for the landlord to retaliate against a tenant. Retaliation is a defense in an eviction case. So say, you're paying your rent on time, everything's going well, you raise these warranty of habitability issues, and then all of a sudden your landlord says, oh, we're going to evict you because of some sort of lease violation or something like that. And they've kind of sort of created a problem because they are upset that you have raised these issues. That would be a situation where maybe the defense you would bring is that they did that in retaliation, because they are not allowed to do that, and that would be a defense to an eviction. Retaliation could also look like increasing your rent or decreasing your services. All of a sudden, maybe they used to pay for a certain utility, and now all of a sudden they're not doing that anymore, and the timing sort of lines up here. Terminating or not renewing a rental agreement, that could be retaliation. Bringing or threatening to bring an action for possession. This doesn't happen often, but we have had situations where landlord will be like texting the tenant and say, you called code enforcement, I'm going to get you out of here. So that's a very clear retaliation. Most landlords are smart enough that they're not going to do that, but even a threat, even if they don't actually file the lawsuit, would be retaliation. And basically just taking any sort of action that intimidates or threatens the tenant, or causes them to feel fear about that action that they took. So definitely always like to remind folks of this, that this is illegal. There are defenses about it. There are remedies for this. But definitely is a very real thing that if you call code enforcement and you say, come down to my unit A, and there's all these problems, the landlord's going to know that that was you who did that, right? And so, even though some of these things are, or even though retaliation is illegal, it doesn't mean that a landlord won't engage in these practices. But hopefully having this information, maybe connecting with an attorney, those types of things will help you feel more safe with taking some of these actions. But definitely is a good thing to be aware of, because it can happen. That being said, sometimes with code enforcement, there could be ways, or sometimes with organizing, there could be ways that maybe the landlord doesn't know that it's you, or that it's just you, right? Maybe part of the organizing is it's a group of tenants, we're all going to make this call on the same day, or maybe it's about a common area issue, or it's like the whole property has an infestation or something like that, and it's not necessarily something tied to your unit. Those are possibilities as well. All right. I keep having to move my little screen so I can see the presentation. All right, so then if a tenant does retaliate, like I said, there are remedies for this. A tenant can raise retaliation as a defense in an eviction, for a monetary eviction, which means it's an eviction based on non-payment of rent, or for an eviction based on the tenant overstaying after the landlord allegedly ended the tenancy. So we talked about that could be retaliation. Tenant does not need to prove that retaliation was the sole reason that a landlord engaged in any of the activities on the previous slide. So there could have been other reasons, but if retaliation was one of those reasons or sort of informed their decision, then that would be the defense here. And then a tenant is able to recover damages if they're able to prove that retaliation occurred. And typically what the damages are is, or they're not going to be more than 3 times your monthly rent or 3 times your actual damages. So if you're able to show that you suffered actual damages, maybe you had to move, and so you had to pay a new deposit, you had to get a rental truck, all those different, expenses of moving, then you could argue that you should get 3 times your actual damages, which could be more than your rent. So whichever is greater of the two of those. Also, tenants, this is another reason why tenants would be able to terminate a rental agreement if a landlord retaliated against them. That could be a situation where now somebody feels very unsafe in the home. They do not feel, if their landlord is threatening them or intimidating them, these types of things. That could be a situation where the right remedy is to move and get out of that situation. Again, that is not an option for a lot of folks, but it is available if it's something that could be an option for a tenant. So that is everything that I have for tonight on warranty compatibility. This is a lot of information, and we talked about a lot of common conditions, common situations, and landlord's rights and tenants' rights. But as I mentioned at the beginning, and some of you were here, some of you may not have been here, but if there's anything else that you're curious to hear about that we didn't talk about or that you'd like to hear a little bit more about, definitely happy to answer questions. Just would say to keep things hypothetical. Just kind of talking about a condition hypothetically rather than my landlord did this and what should I do? And if you are in need of specific legal advice, maybe for you or a friend, something like that, I can, before we close out, put our intake information, our online intake information in the chat, and that would be the place to go in there. And you can always put in the form how you heard about us, which we keep track of when community partners and things like that are referring folks to us to try to review those quickly. So does anybody have any questions about anything that we discussed? Any feedback? Anything that they would like to learn a little bit more about?
Any questions for Haley? Thank you, Haley. That was very comprehensive.
Yes, of course.
I have one that's specific to your presentation and one that's a wondering.
Yeah,
I'll give people another minute or two to think about their questions before I ask so that I don't monopolize the whole presentation.
no problem.
Looks good. All right. So I was trying, like in my head, as you were doing 24 hours and then 7 days and then alternative unit or 72 hours and 15 days or whatever it is and alternative unit.
Yeah.
Is there, I know a lot of these guidelines are kind of fresh and new. Is there any kind of real hard and fast guidelines for when the tenant can request the alternative unit? In that timeline, it sounded like that was kind of fluid when you were presenting it. It isn't like 24 hours, then 7 days, then move out. It was a little more back and forth.
Yeah. So I would say that you could request the unit after there is a breach if it's warranted. So some situations, like maybe a toilet isn't working or something, not going to be something that you would move to a different unit to. But say there is no heat. Um, so I would say that there is a breach after you have notified the landlord and they haven't addressed it within that, or they haven't started the remediation within that hour timeline. So you could definitely request it there, even if they are in the process of fixing it and they're going to get it fixed within that 7 days. I think even if there isn't quite a breach yet, depending on how much it is going to affect life, health, and safety. So maybe it's a situation where it's not, there's no heat, they can't fix it until tomorrow. It's not safe to, stay in the home overnight without heat or without some sort of warming something. That could be a situation where you could request maybe a hotel for the night or something like that. So don't have to wait for those 7 and 14 day periods to pass before you make that request.
Excellent. Thank you. So it depends on the severity of the breach and what's kind of in the deal. And then if last night your heater broke, yesterday your heater broke, and you're going to have to stay last night, like in real time in an apartment, maybe you say, gee, it's going to be 6 below tonight. Can I stay somewhere else? I know you're working on this.
Yeah,
Okay,
definitely.
got it. And then this is a very Colorado specific statute, yes?
Yes, it's similar to other state statutes, but yes, we're talking about Colorado statute, yeah.
Okay. And that's my curiosity. Are there federal minimums, or is this really state to state to state?
If you have federally subsidized housing, so where you're living, or maybe you have a Section 8 voucher, or the like you're living in a project subsidy, something like that, there could be other requirements that are imposed at the federal level. But I think that the warranty of habitability, the one that exists in Colorado that we're talking about, is specific to Colorado. I think that every state has one. Um, but I don't think that there's anything at the federal level that kind of governs all of this. I would have to check to make sure, but I don't think so. That's a good question.
Okay. Yeah, just it occurred to me as I'm listening, like I couldn't even imagine trying to keep track of 50 states versions of this. So I didn't know if any of the states just sort of had a default minimum that someone had provided. So um, didn't expect there to be a hard and fast answer, but thanks for entertaining the question.
Yeah, of course.
Folks, thanks for navigating here. Um, I know that I understand through my texts were blowing up at 6 o'clock that people were having trouble finding the link. So I appreciate that you allowed me to record this. Um, I will send this out to everybody who RSVP'd for this presentation. I do want to take a minute and really thank Haley for giving her time to us tonight. That's a really big thing. I think it would be just kind of fun in the 2 minutes we have left for Steve and Matt to kind of introduce yourself to Haley and let her know who she's talking to. So Matt, if you have a second, Steve, you have a second to just say hey
Yep,
and
I'll go first. Sorry, guys. I was the last 15 minutes I jumped up to make dinner. But was listening because that was my question that I asked, just thinking about like like you said, damage deposits and stuff like that being commonly fodder. It's interesting that you have a whole other a whole other reality for that. So I'm the coordinator for District 12 Educator Association. I will absolutely, with your permission, put the link to this in our upcoming newsletter so people could access it if you're willing to. Really great information. My only wish was that this existed like 30 years ago when I was a renter.
Yeah, absolutely. Please share.
Well, thank you so much.
Matt. Matt, are you with us? Okay. All right. Thank you, folks. We appreciate your time. Thank you, Haley. We appreciate you. Um, everyone have a hopefully a warm, habitable evening.
Thank you all.
Thank you. Take care.